The last few weeks of the semester, we're going to focus on studying evidence. So a couple of things to keep in mind as we go through it. One, we're focusing on the Pennsylvania rules of evidence. There are federal rules of evidence which are similar but not identical. So if you have had opportunity to work under those rules or to study them, they're not going to be exactly the same. So we are focused on Pennsylvania rules of evidence. Also, we are focused on them as they pertain to civil cases, not to criminal cases. So if you have taken the criminal evidence course, that course is a lot more in depth than what we are able to do here, but it is focused on criminal. And so there are some aspects of the rules that we are not paying attention to because they are more criminal than they are civil. So what you're generally hearing should be consistent between this and your criminal law class, but there are going to be some differences just because of the criminal civil distinction. So really, please keep that in mind. It'll make it a lot easier and avoid some confusion. Okay, so the first thing we're going to talk about is why we even care about the rules of evidence in a civil litigation class. So our focus here, which again is why the focus is a little bit different here than in your criminal evidence class if you take that, our focus here is to try to provide you with enough information so that when you are working on developing a case, you understand what information is needed. So we've already done a lot of discussion on what information would we go out and get, in a particular type of case. But once we start actually getting that information, once we talk to a client, once we start talking to witnesses, once we start getting documents, it's important that you have some idea of how this information can and cannot be used in court. So to give you an example, you're talking to your client and your client tells you some information about their case and you ask them, how do you know this? Did you see it firsthand? Did you hear it firsthand? Did someone else tell you? And they say, oh yeah, I didn't hear anything about this myself, but my friend Mary told me this. Okay. We would recognize right away that we have to go talk to Mary because Mary is at least potentially the person with the firsthand knowledge. And when we get into court, we have to bring in people who can testify firsthand knowledge, not people who are going to testify to hearsay, because hearsay isn't admissible, generally speaking. So that's what we're focusing on, is what are these rules that are going to likely help you as a paralegal working in a civil practice, and to a certain extent a criminal practice, but specifically a civil practice, in terms of what information do you need, from whom do you need to obtain it, and once you start gathering the information, what else do you need to do to try to ensure that this is valid, verifiable, and usable information. So that is our focus. So in the textbook, they talk about the 3 R's of evidence: real, reliable, and relevant. Okay, so real, reliable, and relevant. So it's kind of catchy, the 3 R's of evidence, but it may help you kind of remember some of the smaller details if you remember the bigger concepts. So what we mean by real is that it claims to be what it purports to be. That if we say these medical records are plaintiff's medical records, they are in fact plaintiff's medical records, they are real. Or when we say this is a fact of the case and defendant ran the red light, that is real information. It is a real actual fact of the case. Reliable means trustworthy. And so just how we would use that term in any way is exactly how we mean it in the legal field. And relevant, and this is the trickiest one for people to grasp, not because we don't understand what it means, but to articulate a definition. And you will have to articulate a definition of this on the final. Relevancy means that this piece of information tends to prove or disprove a fact of the case. Now you can look at the rule of evidence that deals with relevancy. It's a little bit longer definition. They also define it in the textbook. I tend to go with the ones that are more simple and easy to remember because that way you can restate it over and over again. You're not going to forget it, but it also makes sense when you're trying to apply it to a particular situation. So if something is relevant, it means that it tends to prove or disprove a fact of the case. Sometimes people will want to define it's relevant if it's material, it's relevant if it matters, it's relevant if it's makes a difference, which are all a start to a definition, but it is not a complete definition. So tend to prove or disprove a fact of the case. So we're going to come back and look at all 3 R's in much more detail. So before we get into that, though, we want to talk about what exactly is evidence. And so when we say evidence, we're talking about what can be admissible in court. So what can be admissible, what are the different categories of evidence, and how do we use it? So the first category is testimony. So we have witnesses come in and testify. A lay witness is someone who's going to testify to his or her personal knowledge. So if I see an accident, if I'm standing on the corner and I see a car run a red light and hit another car, I can come into court and testify to it. It is my personal knowledge. If I tell you later about the accident, you cannot come into court and testify about it because it's not your personal knowledge. So it's something that we have firsthand knowledge of, not something that we learned because somebody else told us about it or that we read it somewhere else. And so they give, I gave you the page numbers in the text where you can go and read more about this. So that is our lay witness. Our expert witness is different. An expert witness doesn't necessarily have any firsthand knowledge. If we're bringing in a medical expert to talk about our client's injuries and the prognosis of those injuries, this person may have never met our client. Typically, medical expert witnesses, they've reviewed all of the medical records, they reviewed all the test results, and they make their prognosis from there. Similarly, we want to bring in somebody to talk about what the likely cause of an accident was. They didn't actually see the accident themselves, but they've reviewed all the documentation, they've done appropriate testing, and they can come in and give their expert opinion. So they are testifying based on their area of expertise or specialized knowledge or accomplishment, and their expertise may be education-based. It may also just be experience-based. You bringing in a mechanic, they may not have a higher education, they may not have a PhD, but they could still be an expert in the field based on their experience and their specialized knowledge and their skills. So that is one difference between the lay and expert witness. Another difference, which is huge, is that an expert witness can testify to an ultimate conclusion in a case. Lay witness cannot. Medical malpractice case, we bring in another medical expert who is going to testify that based on their experience, that they believe that the doctor in question did not exercise the appropriate standard of care and was negligent and caused plaintiff's injuries. They can do that. A lay witness cannot. I can see that car accident and I can come into court and testify as to what happened, but I can't testify as to what caused it. I can't say, but I believe that it was the driver's faulty brakes that caused the accident. I can't do that. The expert could come in and say, based on my review of all the data, based on my expertise, based on my experience, my conclusion is that, the driver was going too fast in order to make a sufficient stop before striking the other car, or, it was the brakes. They can come in and testify to that ultimate conclusion. And so a very important distinction. Okay. So testimony, lay and expert witness testimony is our first type of evidence. So our second type of evidence is exhibits. So testimony and exhibits are the two most common ones, types of evidence, and what you're going to see in any type of case that goes to trial. Exhibits, think of exhibits as tangible evidence, things you can touch, things you can see, things you can feel, that type of thing. And there's basically 3 different categories: physical or real evidence. This is probably not the one we see most often in civil cases. This, of course, can be huge in criminal cases when you're dealing with things like fingerprints and weapons and those types of things. So we don't see it as often in civil cases, but it certainly can still happen. So say in our case that we are working on, it turns out that the brakes on the truck are somehow faulty. Defendant could bring in the actual brakes as an exhibit. That would be a physical or real evidence. I had a case where opposing party brought in the children's dirty clothes as real or physical evidence, which, as an aside, I thought was a very stupid exhibit, just because toddlers get dirty. And so, and that's all it was. It was just normal dirty clothes, but they were trying to prove a point that they sent the kids to my client in clean clothes and she brought them back in dirty clothes. So they gave the dirty clothing, which I'm pretty sure had absolutely no bearing on the outcome in the case. But that's an example. Another thing when we're dealing with physical or real evidence that differs between civil and criminal cases, and in criminal cases, as you know just from watching TV and movies, is that there's a chain of custody. And if there's a piece of evidence, they have to account for where that piece of evidence has been every single step of the way. Civil cases, not quite the same thing. In civil cases, what we need to be able to do is have a witness that can testify that whatever it is we're offering into evidence is in substantially the same condition as it was at the time in question. So, for instance, the dirty clothing, it was the husband's new wife that was testifying, and the attorney showed her the clothes, and she had to answer questions saying, yes, those were the clothes that the children were wearing on such and such a date when they were delivered to us. And I've had the clothes since then. I put them in a bag in the closet. And yes, these clothes are in substantially the same condition as they were on the date in question. And that is enough. So she didn't necessarily have to account for every single step of the way. So, so we don't really have the chain of custody. And I just see in the materials I put chain of command, which is obviously wrong. It is chain of custody of physical evidence. We don't have to account for things every step of the way like we do in criminal cases, but we have to be able to have a witness who can truthfully testify to that the condition is substantially the same as it was the time in question. And if you do ever have a situation where a client brings you a piece of physical or real evidence, always check with your attorney. We usually do like to hold on to it. We like to put it in a safe place, but you just want to make sure you follow your law firm's appropriate procedures. Okay. So real or physical evidence, it's the first kind of an exhibit. The second kind of exhibit is demonstrative evidence. So this is something that is created that demonstrates something about the case. So as it says there, it's something that depicts, displays, or demonstrates a fact of the case. So it's something that is created. We could create it internally. We could have an expert create it, do a computer recreation of the accident. But it could be, a chart, a graph, a photograph, but something that we have created to show something. This is a fairly common type of exhibit, demonstrative evidence. You want to show the jury the roads where the accident happened. You take a picture of those roads, or you, want to, give them a better idea of how the truck was coming down the off-ramp and where the bus was, and you do a computer recreation. That is a demonstrative exhibit, and so those are allowed in court. The third kind of exhibit is probably the most common one, the documentary evidence. So it is any sort of document, video, photograph of the actual event. So, this would be our medical records, our contracts, if it's a contract case, if it's libel and it's written defamation, the actual written defamation, you bring that in. It could be business records, education records, bills. So anything that we can touch that's on paper, or anything such as an audio or video recording or photograph of the actual event, that's documentary evidence. So if you do any sort of litigation, you will absolutely always have documentary evidence. You may not have as much as the others, but documentary evidence is the main exhibit that we tend to use. So those are our first two types of evidence: witness testimony and exhibits, with the three different kinds of exhibits.